Okay, welcome back to another episode of Intellectual Property. Today is the last class in our trademark section of the class. So we're going to be talking about trademark fair use, specifically descriptive use, nominative use, use in parity, and so on, comparative uses, etc. Okay, so we've identified different kinds of trademark actions. Of course, we've got infringement actions over both registered and unregistered marks. We didn't talk about trademark counterfeiting, but reproducing fake copies of a trademark product is, of course, infringing and can come with additional, even criminal penalties. And then trademark dilution, which includes both blurring, so reducing the distinctiveness or reducing the association with the mark by using a similar but non-confusing mark, and tarnishment, reducing the distinctiveness or value or goodwill associated with the mark by disparaging it. Okay, but there are defenses, or at least arguably defenses, to both infringement and dilution, which are often described as fair use, descriptive fair use, nominative fair use, something along those lines. And effectively, what the Lanham Act provides is that the use of a mark otherwise than a mark, right? So in other words, if something's a mark, but you use it in a way that isn't use as a mark. In other words, if you use a mark not to identify the source of a product or service, but for some other reason and in good faith and fairly, then that's not an infringing use. And there's lots of different ways in which you can do that, right? And similarly, when it comes to dilution, there's a specific exclusion for this kind of nominative, descriptive, fair use, use not as a mark. Okay, so how does that work in practice? Everyone's probably familiar with the well-known perfume luxury brand Chanel and their flagship product, Chanel No. 5. Well, in the 1960s, a fellow named Smith was running a company known as Tehran, and he was selling a variety of different knockoff perfumes. Essentially, what they'd done is go out and try to clone a bunch of really popular perfumes and then sell them at a big discount, right? So Chanel No. 5 was selling at $25 a bottle back then. It's considerably more expensive now. And they had a knockoff. They had a clone of the Chanel No. 5 perfume called Second Chance. And Second Chance was only $7. And in the advertisements for Second Chance, they specifically name check Chanel and say, that's a mark, right? Compare our perfume to Chanel. It smells just the same, but it's way cheaper. Why not buy our version? Well, Chanel's not happy about this. They bring a trademark infringement action against Smith and Tehran. And the ultimate conclusion from the court is this isn't infringing. This is comparative advertisement, right? They're entitled to make a clone of your perfume. You don't have any ability to stop them from recreating Chanel No. 5. It's not patented, right? They haven't stolen a trade secret. You can't get copyright protection over it or something like that. They're perfectly entitled to make their own version that they hope smells exactly like Chanel No. 5. Maybe it does, maybe it doesn't, right? But they're entitled to tell consumers that that's what it is as well, right? If they want it to smell like Chanel No. 5, they think it smells like Chanel No. 5, they can tell consumers this perfume smells like Chanel No. 5. Now, might not be true. That could be misleading advertising, I guess. But they can certainly use the name Chanel No. 5 to identify what product they're trying to copy, insofar as they're allowed to copy the product in the first place. Why? Because consumers aren't confused about what they're buying. Consumers know they're buying Second Chances, which is a knockoff of Chanel No. 5, and they specifically know that what they're buying is not Chanel No. 5, therefore it's not an infringing use. Casebook discusses some similar litigation around the Splenda brand. We talked about this earlier, right? To what extent is information being communicated to consumers by the trade dress of the product packaging in under the circumstances, right? As we recognized, the yellow is communicating a lot of information to consumers about the nature of the product that they're buying, and in most cases is not confusing to consumers because consumers are going to look to the name on the product rather than just the color to determine whether or not it's in fact a name brand product. However, the court did find that the giant brand version on the far right was too close to Splenda and might call up associations with the Splenda brand based on the look of the packaging. Query whether or not you find that conclusion compelling. Okay, what happened in KP Permanent Makeup v. Lasting Impressions got all the way to the Supreme Court. So KP Permanent Makeup had been using the term microcolor for a long time, and Lasting Impression went out and registered the term microcolor as a mark for its product, and microcolor used in a particular way. What is it? It's a form of permanent makeup. Basically, it's tattooed makeup for the face. Here's an example of microcolor. And Lasting Impression threatened to sue KP Permanent Makeup. They brought a declaratory judgment action to say that their use of microcolor was not infringing on the mark. And here you can see that the different ways that they're using microcolor in different contexts, right? Lasting Impression seems to be using microcolor in a very graphical way to sort of indicate something about the product that they're selling, whereas KP Permanent Makeup uses it in a much more restrained way. And ultimately, the conclusion is that use under the circumstances is descriptive of the product in question. And therefore, KP Permanent Makeup is not using microcolor in a trademark way that would be confusing to consumers. And therefore, Lasting Impression can't stop them from using it under the circumstances. And one of the interesting things here is that sort of the way the Supreme Court describes the back and forth in question. Essentially, Lasting Impression wants to say, look, we made a prima facie case of infringement by showing that there's potential confusion based on the use of the term microcolors. We think that then there should be a shifting of the burden onto KP Permanent Makeup in order to affirmatively prove fair use, to disprove the likelihood of confusion. The Supreme Court says that doesn't make any sense, right? I mean, if we take your position, then proving a prima facie case of likelihood of confusion forecloses the ability to make a fair use defense in the first place. The burden of confusion is on the plaintiff, not on the defendant to disprove it. Therefore, if KP Permanent Makeup can make it agnostic, that's enough to avoid infringement liability. The burden has to be on Lasting Impression to show that consumers are going to actually be confused under the circumstances. This really starts to bring into question how we should think about trademark fair use for the purpose of the analysis, right? Is it really an affirmative defense at all? Or is it really part of the initial inquiry? Is it part of the analysis as to whether infringement, or rather whether confusion exists in the first place, right? Should we make it a two-part test, or should it really all be on the front end? Part of the burden of the plaintiff to prove consumer confusion is to show that it isn't a descriptive fair use in the first place. Okay, in the Swarovski v. Building 19 case, what happened was that Building 19 is like a wholesaler, basically, and they got a hold of a bunch of Swarovski product. Basically, it's sort of an insurance sale after a warehouse had been damaged. So they got this stuff at a big discount, sort of their modus operandi. They're going to sell off this Swarovski crystal, make a killing because they got some really good product that they picked up for a song, right? So what do? They put out an advertisement that says in big letters, Swarovski crystal, we got it for sale, blah, blah, blah. And Swarovski's not happy about this. They like to sell their stuff at a full markup. They don't want to be competing with somebody who got their product for cheap. They bring a trademark action asking for an injunction. And the district court says, well, consumers aren't really going to be confused. Under the circumstances, they're telling the truth about what they're selling. This is a nominative fair use. It is Swarovski crystal. They're not lying about what it is, right? The way they're using it, the context says, useful information to consumers, but maybe they're making Swarovski a little too prominent in their advertising, right? They're kind of overusing them or using more than they have to. So the district court essentially says, nah, you gotta scale it back on the Swarovski part in the advertising. So they redo the ad as the one in the middle where they put Swarovski with a little circle R as tiny as they possibly can. Ultimately, the First Circuit says that's not the right analysis, right? You got to be analyzing under the circumstances whether consumers are going to be confused at all. And here it seems pretty clear. Consumers know pretty well that this is not a Swarovski sponsored event, and therefore shouldn't have been a problem. Okay, so essentially, we've got these tests for nominative fair use, which is what the court applied. Just a question of how to think about it. And the ultimate lesson, I think, is largely to think about it in context, right? When consumers look at the use, is it use in a way that's conveying the source of the product, or is it identifying the product that's being sold? Is it confusing consumers about who's ultimately selling or endorsing the product in question? If yes, then it might be infringing, but if no, then it's not. Okay, we can think about this in the context of other circumstances, but then let's also talk about trademark parity. Okay, so what happened here? Louis Vuitton, obviously a famous luxury brand as well. They sell a lot of very expensive handbags, and a dog toy company, Haute, Diggity, Dogg, decided to produce parody dog toy handbags that they were selling. So this is one called Chewy Vuitton, and it's a kind of a tongue-in-cheek reference to the Louis Vuitton bag. Louis Vuitton bag selling for $1,100, Chewy Vuitton selling for $10. Still kind of expensive for a dog toy, but whatever. Louis Vuitton brings both an infringement and a dilution claim against Haute, Diggity, Dogg and loses on both counts, right? Essentially what the court says on infringement is, look, we can go through all these factors and think about the analysis, but at the end of the day, every consumer who sees this product knows that it's a parody. It's not a Louis Vuitton product. This isn't what Louis Vuitton sells. Louis Vuitton isn't in the market of selling parody dog toy versions of its products, and consumers clearly know that the Chewy Vuitton tote bag is not sold by Louis Vuitton, and the factors are sort of beside the point. Now, the dilution analysis is a little more complicated, but at the end of the day, the court essentially says, look, we have to read a parity exception into dilution as well. There might be some circumstances in which it might be a problem, but Louis Vuitton has a super strong brand. It's not going to be blurred by a dog toy like this one, especially a parody dog toy. And the same is true of tarnishment, right? The associations with Louis Vuitton aren't going to be reduced or destroyed because the dog toy is allegedly of poor quality or something like that. That's just not how it works, and we're not going to accept that framing of the claim and allow you to go forward with it.